Welcome to the portion of the AMCTO HR Law program that deals with occupational health and safety. The focus of this segment will be the Occupational Health and Safety Act, which from time to time I will refer to as OHSA. Here's the outline of what we're going to be covering in this module. First, we're going to talk about who's covered under the Act. Secondly, we're going to talk about the duties of various persons and entities, specifically the employer, the worker, and the supervisor. Thirdly, we're going to talk about joint health and safety committees and health and safety representatives. Fourthly, we're going to talk about the employer's obligations regarding the reporting of incidents and accidents. Fifthly, we're going to talk about the process surrounding the refusal of unsafe work. Sixth, we're going to identify the powers of the inspectors under OHSA. Seventh, we're going to talk about the difference between inspections and investigations. And finally, we're going to talk about workplace violence and harassment, which has been traditionally referred to as Bill 168, but Bill 168 is now part of OHSA. The Occupational Health and Safety Act is a very comprehensive piece of legislation. It consists of the Act itself and a number of extensive regulations. For example, the program, which is known as WHMIS, is in fact a regulation under OHSA. OHSA is regarded as being one of, if not the most comprehensive piece of health and safety legislation in the world. OHSA applies to most workplaces in Ontario. Exceptions to that would be things like farming operations, teachers, and federal workers who are covered by the Canada Labour Code, which has provisions regarding health and safety. It's important to note that the definition of employer in OHSA has been given a very broad interpretation. This was made clear in the 1992 Ontario Court of Appeal case, referred to as the Wyson case. What happened in that case was as follows. Mr. Wyson was a window cleaner who entered into a contract to clean the windows of 4 high-rise condominium buildings. One of the buildings was beyond his capabilities because it had overhanging balconies. So what Mr. Wyson did was he contracted with a Mr. Coutu, who was an experienced window cleaner, to do the building. Mr. Coutu used his own equipment and his work was not supervised by Mr. Wyson. During the job, Mr. Coutu unfortunately fell to his death. Mr. Wyson was charged under OHSA for failing to take every precaution reasonable in the circumstances for the protection of a worker. At trial, Mr. Wyson was acquitted on the basis that Mr. Coutu was an independent contractor and therefore was not covered under the Act. However, that decision was reversed by the Ontario Court of Appeal. That court noted that the definition of employer in the Act covered 2 relationships. Firstly, that of a person which employs workers, and secondly, that of a person who contracts for the services of workers. The Court of Appeal found that that definition permits the devolution of work by contractors and puts that contractor in the position of an employer with respect to his subcontractor. What this means in practice is that municipalities and other employers need to take steps to protect themselves in terms of hiring contractors and subcontractors. Typical steps would involve the entering into a written contract confirming that the contractor or subcontractor has a health and safety program and that that contractor's employees have been trained on that program. In addition, it's a good idea to have at least orientation for the contractor and possibly its employees, if not training on health and safety matters that pertain to the job in question. And if the municipality's employees see one of the contractor's employees doing something stupid, such as not wearing a safety harness on a roof or some such thing, they should immediately take steps to inform not necessarily the employee in question, but their contact person with the contractor or subcontractor. The significance of this is that offenses under the Occupational Health and Safety Act are referred to as strict liability offenses, and what that means is that if the defendant or the person charged can demonstrate that they were duly diligent in terms of training and the preparation of policies and the like, then they may be able to evade liability. But if you haven't taken any steps, and if those steps are not reasonable in the circumstances, then any due diligence defense is doomed to fail. This is why policies and training are so important, both in terms of promoting health and safety in the workplace, but also creating a foundation for a due diligence defense if in fact charges ever are laid. Finally, it's important to understand that OHSA is built on what's called the internal responsibility system. In effect, this means that the government has a hands-off attitude towards health and safety, and that the occupational health and safety system in Ontario is built on the devolution of responsibilities to the workplace parties, specifically the employer, the workers, and the supervisors, and we'll talk more about that shortly. In addition, items such as joint health and safety committees are designed to enhance health and safety in the workplace in a self-policing and self-regulating manner. The government only becomes involved in health and safety matters when there is a serious breach or an alleged serious breach of the Act, and also on an inspection basis, as we'll talk about later in this module. Now we're going to turn to a discussion of the rights and responsibilities of various persons under OHSA, specifically employees, which I'll also refer to as workers, employers, and supervisors. Let's start with workers. First, workers have the right to know. They have the right to know about hazards that may affect their job, and they have a right to be trained in terms of how to do the job safely. Secondly, workers have the right to participate, specifically to participate in ways to keep the workplace health and safe by becoming a member of the Joint Health and Safety Committee, or becoming a health and safety representative, or by becoming certified, or by conducting workplace inspections. There are a number of ways that workers can participate in health and safety in their workplace. Thirdly, workers have a right to refuse unsafe work. There's a specific process pertaining to that, which we're going to review later in this module. Workers are required to work in accordance with OHSA and its regulations. So, for example, this means that workers must use or wear the equipment and protective devices that the employer requires the worker to be used or worn. It also means that the worker is not to remove or make ineffective in any way a protective device, for example, a guard on a machine. Neither is the worker to use any equipment or machine in a manner that will endanger himself or another worker. And in addition, the worker is not to engage in any prank, contest, feat of strength, unnecessary running, or rough and boisterous conduct. There's also a duty on the worker to report any problem which pertains to health and safety. So, for example, if there is a guard on a machine and the worker comes to operate the machine and notices that the guard is broken or in some other way ineffective, the worker has an obligation to immediately report that to his or her supervisor or other representative of the employer. As a practical matter, employees do not get charged very often under the Act for failure to comply with their responsibilities under the Act, but theoretically it can happen. Now we come to the duties and responsibility of employers, and perhaps not surprisingly, this is the longest list as among the employer, the worker, and the supervisor. That makes sense because the employers have overall responsibility and control for the workplace, and so the employer is in the best position to promote health and safety in the workplace. On this slide and the next, we have provided only a sampling of what the Act provides in terms of the duties and responsibilities of the employer. They include things like providing information, instruction, and supervision to the worker, when appointing a supervisor, appointing a competent person. And on that point, what that generally means is that the person who is appointed as a supervisor needs to have training as soon as possible, preferably before they start their position, but certainly if they have training after that point, as soon as possible thereafter. The employer is also required to acquaint the worker with any hazard in the workplace that the worker may come into contact with. And at the bottom of this slide, the main duty is bolded, and that is the employer must take every precaution reasonable in the circumstances for the protection of the worker. In every charge that is laid under OHSA against an employer, that phrase appears. And it is the reasonable in the circumstances word or phrase that gives rise to the due diligence defense or the potential for a due diligence defense that I mentioned earlier. This slide continues the list of employer duties and responsibilities. What is of note is the second to last point, which requires the employer to provide a worker with written instructions as to the safety measures related to the protection of the worker, and also to carry out programs for worker supervisors and committee members. Now we come to the duties and responsibilities of supervisors. A supervisor is defined as any person with authority over the worker. So if you think about that in terms of your own workplace, it may be that someone who does not consider themselves to be a supervisor is in fact a supervisor for the purposes of OHSA. The supervisor has a long list of duties, almost as long as that pertaining to the employer. For example, the supervisor is to ensure that a worker works safely, uses protective devices and measures to work safely. The supervisor is required to advise the worker of the existence of potential or actual dangers of which the supervisor is aware. Once again, the supervisor is required to provide the worker with written instructions as to the measures and procedures to be taken for the protection of the worker. And again, we see this phrase, take every precaution reasonable in the circumstances for the protection of the worker. Now we turn to a discussion of joint health and safety committees. This slide deals with the requirements for such committees. The main requirement is that they are required at a workplace at which 20 or more workers are regularly employed. There is some discussion in the case law about that phrase, regularly employed. So if you are on the cusp of 20 regular workers, you should make some investigations as to whether or not you're required to have a joint health and safety committee based on your employee count. The Act contains some requirements about the size of the committee and the composition of it. Specifically, if there is less than 50 employees, the Joint Health and Safety Committee must consist of at least 2 people. If there are more than 50 employees, the committee must consist of at least 4 people. Some committees function well with larger numbers, but there is a concern about getting too large because that can impair the operation of the committee and its effectiveness. Finally, at least half of the members of the committee must be those who do not exercise managerial functions, i.e. they must be regular workers. The Act also contains provisions pertaining to the selection of the members. Generally speaking, the rule is that the workers are to select the members of the Joint Health and Safety Committee that are to represent the workers in a unionized workplace. That is the function of the union. And of course, the employer will select the employer members of the committee. The main powers of the Joint Health and Safety Committee are to identify situations that could be of some danger or hazard to the workers in the workplace, and to meet and to make recommendations to the employer and the workers to improve the health and safety of the workers in the workplace. The employer is not required to implement the recommendations of the Joint Health and Safety Committee, but obviously if it regularly ignores those recommendations and then there's an accident, the employer's legal position is not going to be favorable. Other provisions in the Act pertaining to the operation of the Joint Health and Safety Committee include the requirement that workplace inspections by a certified member of the Joint Health and Safety Committee take place at least once per month. The meetings of the Joint Health and Safety Committee must be held at least once every 3 months, and the members of the committee are entitled to be paid for things like prep time. That's capped at 1 hour unless it's reasonably necessary to have more prep time, meeting time, and other time as is necessary to carry out the members' duties. And the rate of pay is either the regular rate or the premium rate, obviously depending on the terms of the collective agreement or other policy which regulates those issues. Turning to health and safety representatives, such representatives are required in workplaces with between 6 and 19 workers. So obviously they're not required in workplaces with 0 to 5 employees. The selection of the representative, again, is made by the workers or the trade union if there is one. And inspections are to take place once a month, although the Act does go on to say that if that is impractical, then the representative is to conduct the physical inspection of the workplace at least once a year, while inspecting at least part of the workplace in each month. The authority of the health and safety representative and the responsibility of the representative is essentially the same as for the Joint Health and Safety Committee, to identify hazards in the workplace and to make recommendations to the employer and the workers and the trade union if there is one, and also to be paid for such time as is required to fulfill the representative's duties. We're going to turn now to a discussion of the employer's obligation to report incidents and accidents. There are some very specific requirements in the Act which pertain to this subject, and there's been some recent case law that affects the interpretation of these obligations, which we'll review. So in terms of what needs to be reported, it's a fatality or a critical injury, and that's a defined term, a disabling or injury requiring medical attention, or an occupational illness. And it's important to recognize that as soon as evidence of or an allegation pertaining to occupational illness is made by a worker, that should be reported. In the case of fatal or critical injury type accidents, the employer is required to immediately notify the Ministry of Labor, the Joint Health and Safety Committee, or the health and safety representative, and the union. And it's important to note that the written report by the employer needs to be made to the Ministry of Labor within 48 hours. A further obligation in the case of a fatal or critical injury accident is for the employer to secure the scene until the MOL inspector advises otherwise. There are certain exceptions for that. First, the saving of life or relieving of human suffering. Secondly, and this could be important to a municipality, maintaining essential public utility service or a public transportation system. And thirdly, preventing unnecessary damage to equipment or other property. On critical injury accident, which includes disabling accidents, occupational illness, and those requiring medical attention due to accident, fire, and explosion, the employer has to notify the same parties as previously, but this time it's within 4 days. There are potentially severe consequences for failing to comply with the reporting obligations under OHSA as noted on this slide, and specifically the failure to report will be a factor in the decision of the Ministry of Labor inspector to recommend charges and the decision-making of the Crown to decide to proceed with the prosecution. So essentially, if you fail to report, you're putting yourself behind the 8 ball right out of the gate. The reporting obligation was recently significantly expanded in a divisional court case involving Blue Mountain Resorts. In that case, a guest drowned in the pool at the resort and was not reported because the employer did not believe that it was required to report, given that a worker was not involved in the accident and was not present at the time of the accident. However, the resort was charged under OHSA on the basis that they failed to report, and ultimately the divisional court found that the pool was a workplace under OHSA, primarily because it is a place that workers work, and the fact that the workers were not working there at the time of the accident was irrelevant. So the lesson to be taken from this case is when in doubt, report, as otherwise there could be a charge on the basis of failing to report. Now that you've seen how not to refuse unsafe work, we're going to talk about the proper way to do it. Most workers in Ontario have the right to refuse unsafe work, but that doesn't include firefighters, police officers, and ambulance workers. Essentially, there are 5 steps to a work refusal that goes through the whole process. The first is the report by the worker of the circumstances giving rise to the refusal. The second is an investigation by a manager or supervisor on one hand, and a joint health and safety committee member or health and safety representative on the other. They try to resolve the situation. The third step is, while that second step is going on, the worker is to remain available. The fourth step is the calling of the Ministry of Labor in order to get the Ministry of Labor inspector to come in to see if he can resolve the issue. And the fifth step is the investigation by the inspector, who is required to issue a report in writing. So both during the investigation by the supervisor and joint health and safety committee member, as well as during the inspector's inspection, if that occurs, the worker is to remain in a safe place close by, but out of harm's way, so that if there is a need to converse with the worker about the situation, the people investigating can have access to him or her. Inspectors under OHSA have significant powers, which are listed on this slide and the next, and I won't review each one, but it should be noted that they have the power to enter a workplace at any time without warrant or notice. They can require the employer to do a number of things, including conduct tests at employer's expense and to provide a report arising out of that testing. They can interview any person who was in the workplace at the time of any incident and who may have evidence relevant to the inspection. More about that in a slide to come shortly. Inspectors also have the power to exercise warrants. Typically, warrants would be issued in order to allow the inspector to get at documents that are thought to be relevant to an inspection or an investigation, but the warrants can be quite broad in terms of what they require. If you end up dealing with an inspector who has a warrant, make sure that you take the time to read the warrant carefully and note any limitations on it in terms of time to exercise the warrant, place, and the subject of the warrant. In extraordinary or exigent circumstances, the inspector has the ability to exercise any of his or her powers without a warrant. For example, if the inspector believes that evidence is going to disappear very shortly and there isn't time to secure a warrant, then he or she can obtain that evidence without a warrant. Inspectors also have the ability to issue orders. They are typically quite broad. If you are dealing with an inspector who is in the process of issuing an order, Don't be afraid to engage the inspector in discussion about the scope and specificity of the order, because some orders are written so broadly that it literally is very difficult to know what the employer or the supervisor or the worker is expected to do in order to comply with the order. Now we come to a tricky issue, and that is the differences and consequences of those differences between an inspection as opposed to an investigation by a Ministry of Labor inspector. And the lead case on this is the Jarvis case decided by the Supreme Court of Canada. So to illustrate the point, if an inspector shows up on a random or prior notice basis to conduct an inspection and is walking around your workplace solely for the purpose of inspecting, but in the course of that inspection sees something that he or she thinks may be an offense under the Act, the inspector will go into investigation mode, and once that change of mode has taken place, there are significantly different obligations on the part of the workers and the employer and the supervisor. So if the inspector is in inspection mode, then there is an obligation on the part of workers and managers to cooperate in his or her questioning. However, if the inspector has turned into an investigator, and the trick obviously is to know when that point has been reached, and if the subject matter of the questioning is a supervisor or an employer that could be charged, then the legal obligations change significantly, because the Canadian Charter of Rights and Freedoms clicks in the investigation mode. So the trick is, if you are managing one of these inspections, is to check in with the inspector every so often as to whether or not they're conducting an inspection or an investigation. And if they advise you that they're conducting an investigation, you should probably ask them to wait and get in touch with legal counsel in order to get some advice. If the inspector is in investigation mode, there are certain rights under the Charter that flow for the people that are under investigation, and it's important to note that these rights only operate in relation to those that are under investigation, as opposed to witnesses, being people who may have observed certain things but are not actually themselves under investigation. The main rights are the right to retain and instruct legal counsel, to be free from unreasonable search and seizure, to be free from unlawful detention, and the right to remain silent. In other words, the obligation to cooperate in the questioning in the context of an inspection changes to the right to remain silent in the context of an investigation. Section 8 of the Charter deals with the right to be free from unreasonable search and seizure, and the key word, of course, is unreasonable. That implies that reasonable search and seizure is allowed. Section 8 is designed to protect the individual's reasonable expectation of privacy, which we have in Canadian society. So the focus of the cases is on the impact of the subject of the search and seizure. Case law has developed as to the criteria for a reasonable search. First, the search must be authorized by law. Secondly, the law authorizing the search must be reasonable itself. And thirdly, the manner in which the search is carried out must be reasonable. So the concept of reasonableness is flexible and context specific. An example of this is that in the transportation industry, businesses are heavily regulated, and therefore there is a lower expectation of privacy in those situations. In terms of the right to obtain legal advice, Section 10B of the Charter provides that everyone has the right on arrest or detention to retain and instruct counsel without delay and to be informed of that right. So essentially that means that there needs to be a caution or a warning provided before the laying of charges, and preferably before any detailed questioning takes place of the person of interest. So if you're ever in this situation and you are starting the feeling that you may be the subject of an investigation, you need to make a specific inquiry of the inspector in that regard, and if the indication is that you are the subject of an investigation, you need to ask immediately for the right to retain and instruct counsel prior to proceeding or cooperating with the investigation. We're going to turn now to the anti-reprisal section of OHSA, which is Section 50. Section 50 prohibits an employer or anyone representing the employer from dismissing or threatening to dismiss the worker, disciplining or threatening to discipline the worker, imposing any penalty on the worker, or intimidating or coercing the worker because, and that is a key word because it establishes the causation requirement, the worker has acted in compliance with the act or an order, sought the enforcement of the act, or given evidence. If a worker perceives that he or she has been subject to a reprisal within the meaning of that section, then he or she can initiate legal proceedings. She can proceed with a legal proceeding. Specifically, the worker can proceed by way of grievance and arbitration under any collective agreement that is in force in the workplace, or alternatively can proceed with an application to the Ontario Labour Relations Board. These are difficult cases to win for the employer because the Act indicates that this is a reverse onus proceeding, meaning that the burden is on the employer to show that the employer did not breach the Act, as opposed to the worker having to show that the employer did breach the Act. The proof of a negative is always a difficult thing. A few examples of how this section works from the case law. Tominko was a company that operated a piece of machinery called a crown press. What happened was a crown press operator died from injuries that he sustained in an accident when he went behind the press. The evidence at trial showed that at the time of the incident there was no guard or fence of any nature to block access to the back of the press, which was a dangerous area. There was evidence at trial that press operators went behind the press for specific maintenance-related purposes and that the employer knew of that. Not surprisingly, Tominko was convicted. The next case is Rio Algom, which is a company that operates a uranium mine in Elliott Lake. The company had a waste pass dump site which was used for the disposal of mining waste and was reached by rail tracks. There was a gate across the tracks, but the gate had become damaged and developed a significant overswing. On one occasion, a railway car on an adjacent set of tracks collided with the gate, and a worker was killed. There was significant evidence at trial that the workers had advised supervisors of the fact that the gate was damaged, but nothing had been done by the company. Once again, the company was convicted. In the Cottonfelds case, an employee undertook to clean a machine which was still operating. His arm was sucked into the machine's rollers and as a result had to be amputated below the elbow. The evidence at trial showed that another employee had injured his thumb while working on a similar machine while in operation, and that management knew that machines were being cleaned without being turned off. Once again, the company was convicted. Now we're going to move into the section which deals with Bill 168. In April of 2009, Bill 168 was introduced with much fanfare to deal with the issue of workplace violence and harassment. The purpose of the bill was to address those issues by creating new obligations for employers, such as the creation and implementation of violence and harassment policies. Bill 168 came into being because of a tragic workplace killing that took place in the city of Windsor in about the year 2000. The main features of Bill 168 was the defining of workplace harassment and workplace violence, the requirement on employers to create written workplace harassment and violence policies and programs, Those are two different things. The requiring of employers to conduct workplace violence assessments, provisions about domestic violence as it affects employees in the workplace, and provision for work refusals in the case of workplace harassment and violence. Bill 168 came into force in June of 2010, and Bill 168 has found a home in the Occupational Health and Safety Act. As previously stated, the Bill 168, as I'll refer to it even though it's part of OHSA, contains definitions of workplace harassment and workplace violence. So let's look at the definition of workplace harassment. That definition is engaging in a course of vexatious comment or conduct against a workplace that is known or ought reasonably to be known to be unwelcome. So let's look at some of the main components of that definition. First of all, the word course, that suggests that there needs to be more than one incident. It suggests a pattern of conduct. However, there is some case law to the effect that one incident can constitute workplace harassment, although the norm would be more than one. Secondly, vexatious. Vexatious is generally understood to mean annoying or distressing, so that's really quite a low threshold. The next is that is known, so that means that subjectively the harasser knew that his or her conduct was unwelcome. The next and final phrase is ought reasonably to be known. The word reasonably implies an objective standard, so that if an adjudicator is being asked to determine if workplace harassment took place, they will look at all of the circumstances and determine whether in those circumstances the alleged harasser should have known that his or her conduct was unwelcome. Moving to the definition of workplace violence, essentially that's defined as the exercise of physical force, an attempt to exercise physical force, or a statement and behavior that it is reasonable to interpret as a threat to exercise physical force, all of which could cause physical injury to the worker. The use of the word physical is noteworthy. The two main requirements of Bill 168 are for employers to create policies related to violence and harassment in the workplace, and secondly, to create programs relating to the same subjects. The difference between the two is that a policy is typically a high-level statement of commitment to maintaining the workplace free from violence and harassment, whereas a program is a more particularized document that describes how the policy is going to be implemented in the workplace. With respect to violence, but not harassment, the employer is also required to conduct an assessment of the risks of violence in the workplace. With respect to both violence and harassment, there's a further obligation on the employer to provide information and instruction on the policy and program to the workers in the workplace. In other words, training. You can have the best policy or program in the world and it won't serve any purpose if the employees aren't aware of it and aren't familiar with the features of both the policy and the program. With respect to the issue of domestic violence, if the employer becomes aware or ought reasonably to be aware that domestic violence may expose a worker to physical injury in the workplace, then the employer is to take every precaution reasonable in the circumstances for the protection of the worker. So obviously this is a tricky one due to the sensitivity of the issue of domestic violence, but an example of what precaution might be reasonable would be the escorting of a female employee from and to the workplace to her car in order to ensure that there is no violence exercised on her by her spouse or her estranged spouse. Finally, employees are entitled to exercise a work refusal if they perceive that because of workplace violence they may be endangered. Now we're going to look at some recent Bill 168 law. The first three cases are relatively fact-specific. The last two cases are probably the most significant of the group. In the Shakur versus Mitchell Plastics case, which was a wrongful dismissal action, Mr. Shakur and another employee had been engaged over a period of time in trash talk, off-color language, and salty language, and were also described as acting like two kids in a schoolyard. At one point, Mr. Shakur did strike the other employee on the face with an open hand. The president of the company ultimately decided that he was to be terminated on the basis of just cause. The court referenced the Bill 168 amendments and noted that those amendments have raised the profile of workplace harassment and violence in society. The court also noted that the employee handbook contained rules against threatening, intimidating, or coercing fellow employees, as well as fighting and attempting to injure another employee. However, the evidence also showed that the company had done nothing to train its employees on the intent and purpose of the rules and the consequences of breaching them. Accordingly, the action was allowed, and Mr. Shakur was found to be entitled to damages. In the Walker exhaust case, which was an arbitration case, the grievor was involved in an incident on November 4th, 2011, which involved yelling at a fellow employee and also throwing a metal pipe in the direction of the fellow employee, although it did not strike him. During an investigation meeting, he became angry, removed his gloves and arm sleeves, and threw them in the general direction of the supervisor. Shortly thereafter, there was a second complaint of violence and harassment against the griever on the basis of an alleged physical assault against another employee. The company also learned that the griever had failed to complete an anger management counseling program through the company's employee assistance program. As a result, the griever was terminated later in November 2011. In dismissing the grievance, the arbitration board noted that the griever and other employees had received Bill 168 training. The arbitration board felt that the risk of a similar or even more serious incident of violence or harassment was too high and accordingly dismissed the grievance. In the Reen Canada case, there were 3 separate incidents of angry and arguably intimidating behavior by the griever. As a result, the grievor was handed a 3-day suspension. That was grieved and went before a board of arbitration. In deciding the case, the board noted that all of the employees, including the griever, had been provided with Bill 168 training, which was quite detailed and clearly identified the consequences, i.e. discipline, that could be invoked if violations of the policy were found. The board also noted that the grievor had signed a copy of the company's workplace harassment and violence policy. On the basis of this, the Board of Arbitration upheld the 3-day suspension. The City of Kingston and Cupey case was also an arbitration case. It arose from the termination of a 47-year-old employee who had 28 years seniority, who was alleged to have uttered a death threat against a co-worker who also happened to be her local union president. The grievor had been previously disciplined for incidents involving workplace assaults. However, on the occasion that gave rise to the termination, the grievor and the union president became engaged in a heated confrontation about workplace issues. The grievor made reference to a recently deceased friend of the union president. When the union president told the grievor to leave his friend out of it as he was dead, the grievor allegedly said, "Yes, and you will be too." The evidence at the hearing showed that the grievor did not accept responsibility for her conduct, appreciate the seriousness of her conduct, or what steps she had to take in order to gain control of her anger. The arbitrator found that in the circumstances, there was a concern about continuing incidents in the workplace if the grievor was returned there. Accordingly, the grievance was dismissed. Finally, the Conforti versus Investia Financial Services case was a test case about the jurisdiction of the Labor Board pertaining to Bill 168 cases. The Ontario Labour Relations Board has the ultimate authority over such cases on appeal. The issue was whether or not the board's jurisdiction under Bill 168 extended into an inquiry as to the merits of an employee's complaint arising under Bill 168, or alternatively, whether the board's jurisdiction was limited to whether or not the employer had complied with Bill 168, i.e. had put in place the required policies and procedures. The board went with the latter, narrower position and commented that the legislature could have easily inserted language in Bill 168 that required the employer to keep the workplace harassment free. However, it had not done so, and in the absence of such provision, the board decided that it did not have jurisdiction to inquire into the merits of an individual harassment complaint. This case was good news for employers.